Here he committed a felony by delivering drugs to 2 other inmates in our county jail. So I would recommend a mid-guideline range of 9 months in jail with 1 year probation.
No, not yet from Mr. Nelson. Sorry to interrupt, Mr. Dittrich.
All right, and we're here for sentencing on a charge of jail inmate in possession of contraband with a 5-year maximum. Advisory guidelines were scored at 0 to 17 months. Mr. Nightingale, have you had a chance to review that pre-sentence report with your client?
I have.
Do you have any additions or corrections or scoring challenges?
No scoring challenges. I think the people are going to move to correct his jail credit. No objection to that. He was, I believe, serving a sentence at the time that this was charged. I just am not sure of his out date as to that case.
Okay.
Your Honor, and looking at the old jail list that we have last night, it looks like he served a misdemeanor sentence from July 12th to October 17th. So then October 17th to December 10th would be 54 days credit.
Okay, and so Mr. Nelson, you would not be entitled by law to credit on this case for the time you were serving another sentence. By the prosecutor's records and the jail records, that means you'd be entitled to credit in this case of 54 days rather than 90. So we'll go ahead and make that change. Any other additions or corrections or scoring challenges from the people?
No, Your Honor.
Okay, Mr. Nightingale, anything you want to say on your client's behalf?
Of course, Judge. So Mr. Nelson stands before this court, or I guess he sits before this court currently. A very young man, born here in Sheboygan. What I would say also for him is that he's got great family support. His mom reaches out to me quite frequently. It sounds like he's going through some pretty serious health issues, as indicated by the PSI. I believe that that's what sort of led us to the situation, is that you know, for better or for worse, he felt like he needed to assist his medical situation while he was in the jail serving that sentence. Seems like he made a really poor choice about how to do that. And so we're here accepting responsibility for that. Judge, he's got a pretty limited criminal history that I would classify as limited. He does have 54 days of credit. The recommendation calls for probation. We are going to request to just follow that recommendation. He is more than willing and capable of serving his probation sentence and promises to do so without issue. Thank you.
All right, thank you. Mr. Nelson, it's not required that you would say anything, but it is allowed. Is there anything you want to tell me today?
I would just like to
go ahead and stand up.
Like to apologize for my actions, Your Honor. There's no justification for it. I take full responsibility. All I can do now is accept the consequences and do better moving forward.
Thank you. Be seated. Ms. Goodrich, recommendations from the people.
Yes, Your Honor. The defendant is 36 years old. He has 1 prior felony and 12 prior misdemeanors. He also has a pending shoplifting in South Carolina. Does not appear to be employed, but does have a high school diploma. He was sentenced in district court to 120 days jail on the OWI 2nd. Here he committed a felony by delivering drugs to 2 other inmates in our county jail. So I would recommend a mid-guideline range of 9 months in jail with 1 year probation.
All right, Mr. Nelson, if you want to stand for the court sentence. 36 years of age. Your criminal record has been explained by the prosecutor and by your attorney. You understand you've got some physical health issues, but then, you know, when you're out on a drunk driving second offense, and then you're going to jail, you know you're going to jail, and you smuggle drugs into the jail on your person. And, you know, I don't entirely buy I'm only doing that for medical necessity of my pain, because it wasn't, or was it even prescribed to you?
Yes, Your Honor.
Okay. But you smuggle that into the narcotic-free jail. But then you're like giving it out, you know, so now you're not acting like a patient, you're acting like a doctor and a prescriber and giving drugs to other folks in the jail. That's a very serious matter. I mean, I just read a news article of somebody in Bay County that died from that. You don't know what their situation is, what their tolerance is, what, you know, what's going to happen. It was a planned offense because you knew you were going to jail for the other And you got 120 days on that case. I don't think if you get 120 days in jail and you smuggle drugs into the jail, that your sentence for that crime should be any less than what you went to jail for, right? It should be more. That's how I think common sense would kind of dictate that. So even though we're looking at a 0 to 17 guidelines range, I think that there are reasonable grounds for incarceration, even though it's an intermediate sanction under the guidelines. So for that reason, what I'm going to do is place you on probation for 18 months, subject to the terms and conditions listed in the pre-sentence report. Those include substance abuse assessment and treatment, curfew, employment. You have to pay a crime victims assessment of $130, monthly supervision fee, court costs of $350, state costs of $68. And I'm going to order that you serve 6 months in the Sheboygan County Jail and give you credit for 54 days that you've already served. You have to contact your supervising agent within 24 hours of your release. I understand you're looking to live with your father downstate. We can transfer supervision down there probably without difficulty. You are eligible for early discharge from probation at the halfway point if you've successfully completed programming. So we're going to hand you a piece of paper explaining that. Also, if you wanted to appeal from your conviction or my sentence or both, you could do so by filing an application to the Court of Appeals. If you wanted a lawyer, I would appoint you one, but you'd have to make that request within 6 months of today's date. We're going to hand you a piece of paper explaining those appeal rights. We're going to ask you to initial one copy for us so we know that we gave it to you, and the other one is for you to fill out if you want to take an appeal. Is there any questions for me, Mr. Nelson?
No, Your Honor.
Okay, good luck to you, sir. All right, we're back on the record and calling next the case of People versus Mary Bergstrom. It's two files, 24-6827FH and 24-6898FH. And Mr. Wergo is appearing by Zoom video, and Ms. Bergstrom's appearing by video from the Sheboygan County Jail. We've writted her from Wexford County. Prosecuting attorney Ms. Goodrich is present in the courtroom. I've allowed a breakout room for Ms. Bergstrom and Mr. Wergo. Mr. Wardell, we're here for a docket call on these two files. What's our status?
The court may recall Ms. Bergstrom is a recovery court candidate. Some additional work had been put in to see if she might be a candidate for the Wexford case, and Madam Prosecutor Goodrich apparently has put in a lot of extra work, and it looks like she may be a candidate there. So we would ask for another docket call so that we could allow all of those to culminate and potentially end up with a recovery court.
What is the status of the Emmett County? I know that at one point had been scheduled for sentencing in late October. Do you know if that had taken place?
I do not think it has. I think they found out about the Wexford thing and hit the pause button just as we did, Your Honor.
They're scheduled for sentencing on December 17th.
December 17th. Okay. All right. So where we have things is Ms. Bergstrom has not been accepted into our recovery court program, but there's been some preliminary discussions about that. And before we could go forward on that application, we need to know what's going on with Wexford and Emmett, that they would approve that if we did. That doesn't mean that the team will or that I will, Ms. Bergstrom, but we need to know what's going on in those counties.
Yes.
All right. So she's being sentenced next Tuesday in Emmett. It sounds like we should put this on for the January 7th as well then, so we see what's going on with those counties. So let's schedule this for a docket call on January 7th at 1:10 p.m. And I guess, Mr. Wergo, if you can try to keep communication with your client to know then whether she's going to be in the Emmett County Jail, if she's sentenced up there with a hold into Wexford, or where she's going to be so that the prosecutor can get her either video writted or in-person writted, whichever you prefer. Okay.
Will do, Your Honor.
I'm sorry, I didn't catch what you just said.
I was just saying I will do, Your Honor. Her compliment great with me.
Yeah, same thing. I heard I will, and then I didn't hear the rest of your statement.
I will was the only part important part, Your Honor.
Yeah, we're not hearing the last part. So if it's important, why don't you just tell us that part?
I will.
Okay. All right, thank you. All right, Ms. Bergstrom, you have a good day.
Thank you.
All right, we're back on the record in the 53rd Circuit Court, and we have up next Kobe Shane Wardell. It's a couple files on the criminal docket, 24-6925 and 24-6927. Let's handle those separately because we're live streaming the criminal docket. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
No negative for Mr. Wardell on both files.
All right, and we're here for a docket call and also an ongoing status conference for violation of bond for attempting to contact the victim. And then also it looks like a new show cause for an additional violation. So I should advise Mr. Wardell of that. Mr. Wardell, it is alleged that you are again in criminal contempt of court for violating conditions put upon you by the court. In that you violated the laws of the state of Michigan by using controlled substances while in the Sheboygan County Jail. You get the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt, the right to the assistance of your lawyer to present any evidence in your own defense and to cross-examine any of the evidence presented against you. If I find you to be in contempt, I could jail you up to 93 days and or fine you up to $7,500 or revoke your bond. Do you understand those things, Mr. Wardell?
I do, yes.
And Mr. Nightingale, do you know how we're proceeding on the docket call in both matters and the two pending violations?
Judge, we were going to ask for another docket call. As the court, I'm sure, is aware, I've taken over Mr. Wardell's matters, not just in this court, but in district as well. So we just request another docket call in due course so we can resolve this.
Okay. Would this be appropriate to put over to January 7 at 10 a.m.?
If we could go potentially late January, that would be my request.
That's January 28. We can do at 10:30.
That would be great, Judge. And obviously, if we're able to resolve before that, I will let the court know when we come back to the court. Thank you.
Let's see. All right, so we'll continue the docket call in both files and the status conference and all pending violations to January 28th at 10:30 in the morning. And I guess, Mr. Wardell, I mean, what I'm going to tell you is obviously you're already in the jail and bond's been revoked. So when I say, well, gee, I can give you 98 days, that really doesn't seem to matter. And I understand why that wouldn't matter to you. You have the right to a jury trial and all these things. I'm not making any assumptions here. If you are innocent of all charges and go to trial and you're acquitted, well and good. But if you're not and you're convicted, at some point, you're going to pay the piper for all of these violations. And if you're guilty of anything and you stand convicted in front of me, I'm going to be the one determining your sentence. So you might want to reconsider how many times you want to violate the court orders before you come in front of me potentially for a sentence. All right. All right, now let's move into the family division
Your Honor, before we
Yeah.
do that, I was going to ask as to the criminal cases. I did have Deputy Combs check the phone calls to see if there was still ongoing contact with the victim. And there has been as recently as yesterday. I would ask the court to enter an interim order revoking his phone privileges except for his attorney.
Okay, I mean, Mr. Nightingale, any thoughts as to that?
Judge, I would just object for the record. These are still allegations at this point, but I understand the request.
All right, well, I mean, it's an extraordinary remedy. However, in this case, in one file, he's charged with assault by strangulation, aggravated stalking, committing an assault in the jail, resisting police. The stalking is in violation of the personal protection order that was granted where he's had a prior violation and now he's alleged to have another violation. He's got a second case that again is aggravated stalking and witness tampering with the same victim. He's repeatedly violated court orders not to have contact with the victim. It's alleged that he's committing crimes while in the jail. Mr. Wardell just seems completely out of control. Given those circumstances, I would grant that relief and I would enter a separate order that the prosecutor can present for entry, directing the jail to revoke Mr. Wardell's visitation and phone privileges entirely with the exception of Mr. Nightingale.
Thank you.